By now, most people who are heavy consumers of Australian political media are aware that Christian Porter is suing the Australian Broadcasting Corporation for defamation. There's so much interesting material to discuss about this case, and I thought that I would tease out two really interesting bits. One not so interesting bit that has captured the imagination of people on social media, and one deeply worrying bit. The interesting bit, identification. So I don't need to tell you this, but for everybody else who's watching, there are three elements to a cause of action in Australian defamation law. First, that there was a communication of defamatory meaning. The defendant said something that disparaged me or caused other people to shun me or subjected me to hatred, ridicule, or contempt. Second, the communication was of and concerning me. That is, it identified me. And this is the interesting bit that we'll get to in greater depth. And finally, it was communicated to some third party that was neither me nor the defendant. It's this third man that's the heart of defamation law damage. You made that other person think less of me. Notice that I do not need to demonstrate that the claim made by the defendant was false. In Australian defamation law, true statements can be defamatory. Until 2005, some jurisdictions required defendants to show that their statements were for the public benefit as well as true in order to make out a truth defence. Today, truth alone is a defence to the publication of defamatory material, but falsity is not part of the cause of action. So let's talk about identification. Usually, it's pretty straightforward. The King of France is a jaywalker. I named the King of France. I'm clearly talking about the King of France. I have said something defamatory about him. But what if I don't name him directly? What if I say that there are allegations about a man who wears boots and a suit of red? Well, Santa wears boots and a suit of red. And what if I add that the aforementioned man wears a long cap on his head? Well, Santa wears a long cap on his head. Cap on head, suit that's red, must be Santa, must be Santa, must be Santa, Santa Claus. These details, wears boots, suit of red, long cap on his head, are details that an ordinary reader can use with extrinsic facts to identify the person that I'm talking about. I don't need to name Santa Claus specifically, but I can identify him in other ways for the purposes of defamation law. In an English case, Morgan & Ottom's Press, the plaintiff was not named in a newspaper article, but the reasonable reader could piece together defamatory meanings about him, namely that he was a member of a dog-doping gang that kidnapped a woman who was staying with him. This is the case that most resembles Porter's claim. The article doesn't name him, but a reasonable reader can piece together the identity through various facts, like age and involvement in an event. What is interesting is that I can accidentally identify a person. Remember the three elements of the cause of action. I do not need to demonstrate that they intended to identify me. Maybe I wrote a piece of fiction completely off the top of my dome, but a reasonable person can piece together the identity of a real person. And in that case, you have identification. And the case for this is called Hutton and Jones, where Hutton published a fictional story about a fictional character called Artemis Jones. It turned out that such a person existed and was defamed by the story. And one final point to make is that if you add up all the elements of identification so far, you can realize that it's even possible to defame several people at once. So you can't defame a group of people. For example, all lawyers are liars. But you can defame each member of a group if it is identifiable through the process that we've already discussed. And of course, you can defame two or more people with the same material. The case here is Zoif and Nationwide News, where the paper published material that allowed for the specific identification of two different people. So what's the summary message here then? The ABC did not need to name the Attorney General in order to identify him. This is his argument. There was enough material in the article that pointed the reasonable reader to conclude about whom the article was written. And that is fascinating. Fascinating bit number two, defaming public figures. So, why is it that US elections are way nastier than ours? You might recall that in the 2016 presidential election, a lot of really spicy stuff was written about the Democrat candidate, Hillary Clinton. Really wild stuff. Why was it allowed to be published? Well, it all comes back to this case, New York Times and Sullivan. Sullivan was a public official who was responsible for the police. The New York Times ran an advert on behalf of activists who were seeking funds for legal costs for Martin Luther King Jr. The activists were a little bit fast and loose with the truth, and although they did not name Sullivan expressly, they identified him through other details. The result is the advert was defamatory of Sullivan. Sullivan sued and won in the first instance. However, the New York Times appealed, and it ended up going all the way to the Supreme Court. There, Sullivan lost. The Supreme Court said that if a public figure like Sullivan wanted to sue for defamation, they needed to show that the publication was made with actual malice. Public figures have to meet a higher, practically impossible threshold. In Australia, this issue was considered back in the early 2000s as part of defamation law reform, and it was considered far too difficult. But a reasonable person might argue that such a standard is exactly what this case calls for. If you have these kinds of allegations about a public official, why shouldn't you be allowed to publish them? Provided that you are not absolutely reckless about the truth, why shouldn't you be able to publish? Well, one reason is that you might look at the United States and think, holy God, their system of politics is absolutely awful and could probably be fixed by proper defamation law. But another reason is that you allow a lot of nastiness into politics if you set the bar higher. If you choose to stand for office, for example, should you really be subject to literally anything short of actual malice? And reasonable people disagree with this. Which gets me to the not so interesting topic. Federal politicians suing in their personal capacity in the federal court. The issue of the perception of bias came up on social media, and I promised a few people that I would explain the issue. So let's get our head around what the federal court is first. Most people understand the concept of the High Court of Australia. It's Australia's apex court. And people tend to get that if you hate the decision of a Supreme Court of a state, you can appeal to the High Court. But it's way more complex than this. Most importantly, unlike the Supreme Court of the United States, the High Court of Australia has original jurisdiction. If you have a certain kind of issue arising under federal law, you can march up to the High Court and say, "G'day, I have a bone to pick and I want mandamus." So anyway, this is Sir Owen Dixon's face when he discovered that he would have to listen to everybody bringing their cases directly to him when he was the Chief Justice of Australia. And everybody went, oh yeah, that would be absolutely terrible. The High Court would be constantly bogged down in cases. So they created the Federal Court. Importantly, there were previously two other specialist federal courts, a court specifically for bankruptcy cases and a court specifically for industrial relations. The latter one pops in and out of existence over the decades. And what's fun to note, and something I was going to put into a different video, was that the way we achieve a lot of clarity and coherence is by abolishing specialist courts and merging them into a regular structure. So the federal court here hears appeals from the Federal Circuit Court, except when the Federal Circuit Court matter involves family law, in which case it would be appealed to the Family Court in its appellate jurisdiction. It's really messy, and it's in the process of being fixed in the same way that the Bankruptcy Court was. But wait, if the Federal Court is part of our approach to manage the original jurisdiction of the High Court, why are defamation cases being heard there? After all, the federal court is for federal law, and defamation is, at the moment, state law. The answer emerges from wildly technical reasons involving the Jurisdiction of Courts Cross-Vesting Act of 1987. There's a special relationship between the Supreme Court of the ACT and the Federal Court, meaning that if you are able to sue for defo in the ACT, you can take it to the federal court instead. And to achieve that, You just need to demonstrate that the matter complained of was published in the ACT, and the World Wide Web is, quite surprisingly, available here in Canberra. The case that opened the door on this was Crosby and Kelly. That is Linton Crosby, who, with his business partner Mark Textor, sued the then MP Mark Kelly, who's also pictured there, for hot wild stuff that he wrote on the toots. So that's why we're talking about the federal court at all. The ABC story was published among other places in the ACT, and therefore the Attorney General can sue in the federal court. And now that we understand the issue a bit better, we can stretch this out. If federal politicians can take civil matters to the federal court, isn't there a perception problem? And isn't this even more so when it's the Attorney General, the person who has responsibility for appointing judges? Okay, look, technically, judges are appointed by the Governor General and not by the Attorney General. But in practice, it's the Attorney General who decides and recommends the appointment to the Governor General, who is, by convention, obliged to accept the recommendation. So here's the argument at its highest. The Attorney General is responsible for appointment to the federal court. So maybe a judge will be more favourable to the Attorney General in exchange for preferential treatment in a promotions round. Maybe the quid pro quo is that he'll be made the Chief Justice of the federal court. Or maybe even an appointment to the High Court when Justice Keane retires next year. To some extent, this is a non-starter of an argument because the government is trying a strange arrangement where the Attorney General will not be responsible for the federal court during these proceedings. But there's even more reason to be sceptical about the argument. Late last year, Brian M. Barry, not Brian Barry, the moral philosopher who died in 2009, but a legal academic from UT Dublin, published How Judges Judge. It has a chapter covering the rather extensive amount of debate over the last 50 years about how to understand judicial decision-making, and it's not straightforward. Here is the highly controversial and incredibly divisive Richard Posner. Back in the early 90s, he strongly advocated an economic model of understanding how judges decide cases. Like other rational actors, he said, judges seek to maximize a utility function that includes both monetary and non-monetary elements, the latter including leisure, prestige, and power. Now, by the time that he advanced this argument, Posner himself had been a very senior judge for more than a decade. So let's think about this for a moment. Judges aren't only going to be concerned about getting promotions or currying favour for promotions. They are also going to be concerned about their prestige and their power. And what better way to do this than to be the federal court judge who knocked back the Attorney General's attempt to silence the national broadcaster. Now, Barry's book is really great for working through the extensive amount of literature on this debate. There's empirical evidence about whether judges change their behaviour if they're early appointments or if they're soon to retire. Australia has a mandatory retirement age for judges. Do the arguments about favourable bias apply equally to a judge who, by law, is required to retire in the next 18 months? What possible kickbacks could they be seeking? Or maybe they are the ones who are even more likely to seek the kickbacks. Cosy post-judicial appointments as royal commissioners into this or that or the other. So the problem with the argument is that we see just as many reasons for a judge of the federal court to be favourable to the Attorney General as there are for them to be unfavourable. In fact, there's no reason to believe that judges would be anything less than impartial and fair. This is the former Treasurer of Australia, Joe Hockey. Fairfax newspapers published headlines, "Treasurer for sale," and Hockey sued for defamation. In that situation, Hockey sued in the federal court. I don't think anybody could say that Justice White showed preferential treatment to the Treasurer. Recalling an earlier point in this video, it is interesting to note that Hockey succeeded in demonstrating that the editor-in-chief of Fairfax, Darren Goodsir, had actually been actuated by malice in publishing the material about Hockey. But look, all of this is largely academic now that the government is going to delegate responsibility for the federal court while the matter goes ahead. But there was no real reason, as was suspected on social media, to think that there actually was a conflict here. final point. This is Bret Walker SC. This is the barrister whom the Attorney General has retained to argue his defamation claim. Now, if you read social media, you will know that this is the same evil, diabolical, and truly wicked Bret Walker SC who represented George Pell in his High Court matter. And not only that, this is the same Bret Walker SC who represented tobacco companies when they tried to defeat the plain packaging legislation. Just terrible. What an immoral monster this is. So let's be a bit sharper here. This is the same Bret Walker SC whom, in 2018, the Commonwealth of Australia sued. Bret Walker was the Commissioner of the South Australian Murray-Darling Water Basin Commission and issued summonses under the South Australian Royal Commission Act to Commonwealth public servants. So the Commonwealth sued, saying that Mr. Walker had no such power. The case was eventually discontinued. He also led the inquiry into the Ruby Princess fiasco. He was appointed by the ALP to be the first independent national security legislation monitor. He's currently in an administrative conflict with the Commonwealth about whether he can represent Bernard Collaery in his matter involving Witness K. The same game is playing out on social media regarding other lawyers retained by the Attorney General. One represented Tracy Spicer when she was subject to criticism on social media, for example. And I think there's a real problem here. We need to understand the role of lawyers. And it's not just to provide representation and advice to those with clean hands. Cherry-picking from the histories of lawyers as a way to discredit parties is one of the things that strikes at the rule of law. We have advocates who argue on behalf of the parties, and this gets us efficiencies in the legal system and better outcomes. If we go down the social media pathway, we start to argue that only some people should be able to get legal representation. And that is a bit gross. And that is it from me. Have fun and see you next time.